43.1 then, no?
43 is a transfer petition that's dealing with UP Bihar. 43.1 is the Bengal SLP. And yes, there are companion SLPs as well.
43.1, page number?
43.1, if you watch it from the paper. The recruitment notice is dated 29th September 2022. And that notice, in this case, included us, included DLED 18 months. Therefore, we were eligible, we applied, we participated. The challenge to that notification was taken by those who were the DLED 24 months, saying that we shouldn't be permitted to participate at all in the process. That writ petition first went to the single judge, and the judgment was passed on 29th February 24, allowing their writ petitions against us. Went to DB, impugn judgments 24th July 24, sustaining the
So they had taken a view contrary to the view taken by the Uttarakhand High Court.
Yes, they had. So they had gone with the point that there is equivalence effectively. Therefore, we are permitted to participate in that process. But the single judge and division bench concurrently said, no, we are not permitted. Now, in view of the clarification, all of us are, in my SLP, there are 388 in the SLP and 240 in Recruitment. I think Ms. Makija is representing a larger number.
All in all, it would be about 600 or 650 or something like that. And there are 2,200 vacancies as of now.
We are totally 1,024 from what I understand, all of us put together, Mr. Prasad, Cindy, all of us put together. So we are seeking, Malons, similarly, that because in both Bihar, that clarification has been understood properly. Today, Your Lordship have clarified it for Uttarakhand, and Mr. Gupta's assistance was there before this court on that date when Your Lordships rendered the clarification of 10th December. I don't think there should be any cabin with this issue that we should be eligible and permitted to take part in the counselling. Now, the ones, and we have taken part in the counselling. Our name doesn't feature finally in the select list, but our name should feature in the select list because we were completely eligible. The only question was eligibility, which we had. That's really the only issue that I actually saw.
The NCT has also issued a clarification with regard to all the states.
Yes, NCT was supporting you.
In fact, NCT brought around the scheme with regard to against.
No, at the instance of the Union of India, because that was in order to complete the deadline under the Right to Education Act. But all are you are in employment in 2007.
There's no question. It's the same issue. But I just want to give you the complete picture. There was a challenge in a separate batch of petitions between those who had the DLED qualification as in 2022 and those who achieved that qualification after a month or so. Both 24-month candidates, interstate between the 24-month candidate. There was an issue which was raised, which the High Court held against the people who did not have the 24-month qualification. And that has come up in an SLP. The matter has been heard and judgment has been reserved. Now, in that issue, it was dealing with the same advertisement. Different issue, same advertisement. In which this court passed an order on 29th January 2024, accommodating those from the 24-month DLED who had the qualification prior to the advertisement date. So 9,533 of those posts have been filled up from the entirety of 11,758. 750. So out of that 2,000 balance remains. We believe that we could be accommodated against that. I just want to let you.
Who have been accommodated? Those who are having 18 months diploma or 24 months diploma?
The month was 24 months in that case. So their 24 month before date of advertisement have been accommodated 9,500. There is a small bunch who are achieved the 24 months after the date of the advertisement. The arguments I heard Mr. Gupta, I was there, it was heard, judgment has been reserved in that. So I want to give you the full picture. And
so should we await?
Judgment has been reserved, 24 months versus 24 months. That doesn't have anything to do with
24 months, so there is no issue of 18 months there.
No, that issue is not there. Just to give you the complete picture, that's what things stand.
not accommodate the word, more suitable word would be that they've been appointed.
Number appointed.
Not accommodate, because there's no concession that has been given.
That's correct.
No,
They have not.
That's the
It was against us only on the issue of JV notes, because only JV notes. Now this is a directly clarified notes. Therefore, notes, it should be allowed. That's a short submission.
Well, the Calcutta High Court relies on JV while
Yes. Page 4.
It's only based on JV.
That's all it is.
if they are in employment in 2007 on the cutoff date.
But I'm accepting your lordship's orders in the review order also. No question about it. But I've gone through the JV judgment also. But your lordship's recorded that batch there is a one-time
It's only for those who are up. The cutoff date is I think that August 2007.
Correct.
And we are referred to the entire communication between the Union of India
Yes,
and the NIOS.
In great detail, Millard, your lordship has gone through the entire process. And as I understand it, you have
And we have also held that 18 months was provided.
otherwise the 18 months
Yeah,
also not,
otherwise 18 months is not
an equivalent.
not an equivalent.
But for the purpose of those persons who were in service in
And
27.
as a matter of fact, they were sent for that course by the state governments only.
But actually, Millard, the Swayam portal was something which the state government, at least in West Bengal, had no control over. They applied themselves and they went. Millard, the consequence is a little different. I'm only going to point it out to your lordship. It has, your lordship's order, Millard, is to be given effect to now. There is no question about it. The consequence is this, Millard. For instance, if I take the petitioner, SLP petitioner, Mr. Kaushik Das, he claims that he was in employment on 2017. Now, we find that he has also disclosed TET certificate at page 290 of 2022. So here is a person who under the NCT Act, under the RTE Act, section 23, would not have got employment in any institution because he didn't have TET. I'm just giving an example. So therefore, Millard, we are now a little perturbed that there may be people in this batch who have somehow got some certificate from private unaided schools. So, Millard, what we are saying is, Millard, your lordship may remand the matter back. The persons will have to be verified because there is only one appellant before your lordship in the SLP. But Millard, when my learned friend says 300 people, then Millard, they are coming, Millard, as Millard.
So what we'll do, we'll hold that only such of the persons who are in employment on the cutoff date,
Yes.
they would be entitled to, and that will be subject to verification by the authorities
That's
as to whether they were in employment or not.
That is whether they were validly in employment, because Millard, we suspect now that private schools, Millard.
So here in Uttarakhand also,
Yes.
we are not directed the blanket appointment. We have said that they will be only considered and if eligible,
Yes.
then appointed.
Yes, correct. That is one aspect which I want to bring to your lordship's attention. The second thing I wish to bring to your lordship's attention, my lord, is that as far as this process is concerned, the 2022 advertisement, 11,000 odd vacancies was there, which was advertised. My lord, 9,500 odd have been empaneled, and my lord, appointments have been given. Some 8,700 odd appointments have been given. Now, in this Shomenpal case, which my learned friend referred to, where Justice Narasimha and Justice Mishra's bench has heard us out, has heard everybody out, and only written submissions are to be filed. There, my lord, it was contended by the petitioners that the rest of the seats should be for their benefit. Now, my lord, your lordship may resolve this in any way that your lordship feels, because it shouldn't be, my lord, that one steals a march over the other, etc. Then there'll be some heartburn there.
Just to respond to the TET aspect, that's a red herring that has been thrown by them, your lordships. As far as TET is concerned, 2017 was the notification. They held the examination in 21 and declared the results in 22. And even the now 9,000 persons who have been appointed, your lordships, a large number of them belong to the 22 exam. So
No,
that is,
Let me
so
explain.
that is a red herring which they are.
No, it is not a red herring.
Of course it is.
A person may take a TET examination in 2022 and apply for future employment for the first time. But Millard, here are people who are claiming, just 1 minute. I'm not Millard. Here are people who are claiming that they got employment prior to 2017, but are showing a TET of 2022. So therefore, Millard, if that is so, Millard, then they apparently have got employment before 2027 without a TET, which would be contrary, Millard, to the legislation. So there are people like that.
No, so whether your rules require both diploma as well as TET.
Yes, Millard, it's not my rules. Now the RTE Act has made it compulsory that after a particular date, that is Millard 29th of July 2011, you must have both the minimum diploma qualification and a TET.
And they could have appeared for TET even without having a diploma course.
Yes. TET is an independent examination. TET is an independent examination. You have to have them separately and get it. Now, Millard, suppose today somebody takes the TET in 2022 and applies for the 2022 batch. Then there is
We'll say that those persons who were in employment on that 2017 and who are otherwise qualified, they would only be considered.
Millard, one point, Millard, I'm hesitating to bring it to your Lordship's attention because it may have, Millard, your Lordship would have taken it into consideration anyway. The amendment to the RTE Act, which came in 2017, was for the benefit of people who were in employment on 31st of March 2050. And so, Millard, actually this scheme was for those persons who were in employment on 31st of March 2015, but had not been able to get the diploma, and they were, Millard, actually given an opportunity, this 18-month course. I'm just bringing it to your Lordship's attention. I do not know, Millard, whether this affects your Lordship's, Millard, orders at all. But the section says that if you are in service on 31st of March 2015, then you must get all the minimum qualifications within 4 years' time. So 31st of March 2019 becomes the cutoff date for them. And this amendment is brought in August 2017. So there was only 18 months' time to get them qualified.
But now, therefore, we have already held that.
I leave it at that.
That takes care of
Let
that.
us respond on 3 points. The first is with reference to petitioners before bylaws.
No, there is only one petitioner before your Lordship.
That's what I'm answering.
Yes.
So we will say that all such candidates who are, we will pass an order in rem, not restricting it to the petition, otherwise we'll be flooded with, and we'll say that the state would be entitled to consider their eligibility. And
So I want to respond on that because there is something to be said. Just firstly, I think to correct Mr. Gupta, I have the SLP here. There are 388 petitioners, SLP petitioners, 388. It starts from page 7 onwards, you can peruse it. There are 388 petitioners. Now, there are many who are pro forma respondents, that's different, but I'm just saying there are 388 petitioners. Now, the point that Mr. Gupta took was that, look, you did not have a TET on the date when you were in service and you achieved this 18-month DLED qualification. You actually were ineligible to have been an in-service teacher because you lacked a TET. That's what he's saying. If I understand that argument correctly,
I've given only one anecdotal example because Mr. Kaushik Das's TET result is on record. I don't know about the others.
Mr. Gupta is not wrong. Mr. Gupta is not wrong on the fact that my TET result came in 2022. Why? Because they advertised their TET, which they had run in 2017. They didn't run TET in 2017. I applied. I was waiting. They didn't run it in 2018. They didn't run it in 2019. They didn't run it in 2020. They ran it in 2021 against the 2017 advertisement. I got the TET when you ran the TET. You gave me the result in 2022. So I'm clutching onto this in 2022. There's no other time I could have got it. That's one. Secondly, Mr. Gupta is also right that NCT regulations, which came first in August 2010, and then in July 2011, they made small amendments. Mr. Gupta is well aware that both of us are contesting this issue on mandatory nature of TET, who it applies to, etc. That is part heard before Justice Datta's bench. Now there the question is entirely different. That's a third question which arises. And let's not conflate that with this. About whether those who are in the saddle in 2011 onwards, teachers who have been in service, all of now, whether the teachers who were in the saddle in 2011 require the TET, was it absolutely mandatory? That question is at the moment sub judice. So for the state to endeavor in this case to bring this bogey up, Ms. Makhija is right, to bring this bogey up to create some confusion where you have.
Then we will have to await the outcome of that petition.
What I am suggesting is, let's not get into that for one primary reason. The Lordship will recall that when you dealt with the review petition, you dealt with a series of MAs. Two of those MAs specifically dealt with Bengal. Applicants who were from Bengal came before the Lordship in this very courtroom and argued this matter. The state filed a reply. And let me show you.
But your Lordship didn't go into individual facts.
1 minute. You didn't go. You didn't go.
So if somebody is valid, fine, no difficulty.
The state shouldn't now be taking an additional bogey saying, I agree you were eligible to sit for the NCT 18-month course. You did the 18-month course. You qualified. The court has held you eligible to apply. But prior to you sitting for that 18-month course, your question of whether you could have continued as a teacher with or without a TET is a bogey, man. That I'm sorry. We have been in the saddle for 10 years, 20 years, 30 years. Today, after your Lordship give this clarification, if your Lordship were to employ the words that Mr. Gupta wants you to employ, which is to say that you should have been qualified prior to
No,
you
I'm not
having
asking.
18 months.
I'm not asking.
Then they will.
I'm only
after the
saying
order
that
tell us
subject to
we are
verification, that's all.
We are systemically subject to verification.
Subject to verification.
And subject to
Solve this, Your Lordships.
subject to the verification.
Because the facts of each individual has not been gone into.
Subject to
Yes,
verification.
may I
Like you said,
Subject to verification as to whether they were legally appointed or not.
That's all.
that's absolutely.
To be said, because this is what we are apprehending that the state will do, Your Lordships. Those who were registered for TET in 2017, because it is not my fault that I did not take the exam, they held it after 4 years. It is on their, it's their problem that they held it after 4 years. So I am registered on 2017, exam held in 2021, result declared in 2022, and the persons who are already employed and given employment to are also 2017 TET candidates.
Correct, that's
So
correct.
that
That 9,000 that they've accommodated
Yes.
includes the 2022 TET.
Yes.
Then they shouldn't have accommodated them. They shouldn't have appointed them.
So this should not now come up as a second point of contention and a second round of litigation, Your Lordships.
Let me throw them out
Clarify
once after this court's order directing them to appoint these 9,900. They will have to remove those people who have 2022 TET.
No, I don't have to remove because 2022 TET they have taken now.
They can't.
That's some
They
reason
can't have
I-
TET.
Future recruitments they can use the TET. But is it not my learned friend's contention that they applied for and got a job without the TET?
Of course. I was in service without TET for years. Well, there was no TET.
So therefore,
TET was not a frequent test.
I don't want to get into this because each person will have a different set of facts.
He only brought it up, you only showed.
In
it
fact,
up.
we are finding that in the present IAs, they change their stand from time
I
to time.
would suggest
First they said government
an
school
order
teacher,
similar to the
then
Uttarakhand
the
order,
private.
my lords, where let them verify and just confirm. That's all.
That is what he is also saying.
Facts and
We will not go into the date issue.
in fact, my lord, if I may just add one more thing, my lord, my learned friend has shown your lordship one order of the Calcutta High Court, recent order, which relies on your lordship's my lord review order. There, my lord, that particular individual was before the court and her my lord qualifications had actually been checked and a report had been given by the director that this is all right.
So therefore, we will say that the subject to verification will be eligibility and
Who were registered in TET.
no.
No.
Then we'll await the decision of the
Going to
other.
get a huge problem.
Very good.
We'll await the decision of the other way. No, here the advertisement is what is the rate of advertisement?
29 September 22.
22. And the TET results were declared on 10th January 22.
No, that is not relevant for the.
Anyway, we are not going into date now. We are only going into as to whether you were appointed on a cut-off date, as to whether your and the verification regarding your eligibility and the regular employment. Because we don't want to open a floodgate and get some fake certificate and all that.
Obviously, we'll not defend
Millard,
that fraud, my lord.
Millard, in this state itself, Millard, we have had a situation where once an order was passed by this honorable court in 2011, Millard, hundreds and hundreds of people started coming, filing affidavits saying that I was also qualified on 20. Here also, Millard, multiple implement applications.
How many petitions are there? No, total petitions.
There are
SLPs.
Yeah,
So,
but-
Lordship,
SSLP, there is one.
one SLP in which there are many intervention applications.
Yes.
There are many 100 intervention applications are there.
We'll dispose of all interventions.
Yes, yes.
Close for orders.
Great.
वो draft बना के दे देना.
Hope you won't see us again.
That we don't know.
Millard, I hope, Millard, your lordship will see us, but
Yeah.
not in this.
Not in this
matter.
matter.
Spend on Mr. Gupta's flags. Grateful, Your Lordship.
Yep, yep.
Mr. Gupta, you are happy to go home. Good for you. It will take care of his today's.
This is only 43.1, 43 will have to come on another date. That's for Bihar and UP. There's some other date because the government is yet to respond on 43.
ठीक है 43 के बाद में कर
Any other date. Great for us, simply.
My lordship,
Fee structure well.
this is
Fee structure well.